what a deposition is. It's your sworn statement under oath. But you may be asking, why does the defense attorney want my deposition after I've been injured in, say, a car or truck accident or even a work injury? Why do they want to come and take my sworn statement? And I'll tell you why. They probably have something to try to make you look like a liar. Their goal with the deposition is to capture your sworn testimony so that they can go to trial and say, look, they're not being truthful. And I'll give you a common example. A common example would be a truck accident case where you injure yourself and you have a herniated disc and a surgery, and the defense is afraid of Cantor injury law, and they're afraid of paying you millions of dollars because you had a surgery, and so they've hired a surveillance company, a private investigator, to follow you around secretly and video you. And it frequently is tipped off to me in a video, in a deposition, because they'll ask you very specific questions. What can you not do as a result of this collision? And you'll list your things, you know, I can't lift, I can't bend, I can't stoop, whatever it is. And then they'll say, well, can you go fishing? Something very specific. And you may have told me that you've gone fishing once, but it, you know, was very painful and you were laid up for 3 days after. Or they may say, can you mow your lawn? Those are things, very specific things that maybe they have you on videotape doing. And I never put that past the defense. So the point of the deposition first is to poke holes in your case. And they never ask you the snowball easy question, like, you know, tell me about your day as a result of this. They ask you very specific questions, and they try to make it look like your injury's not that bad. There's two different types of depositions. The first is a discovery deposition, and in Missouri, these depositions can be used for any purpose. You can read a deposition into evidence in certain cases, and certainly if there's if the witness testifies one way and then says something later, they pull it out and they say, do you remember your sworn testimony, your deposition that I took on such and such date on page 36, line 16? I asked you this, and what was your response? And then they read from it. So in Missouri, the deposition can be used for any purpose. There's discovery depositions, and that's where they want to know everything about you, because maybe they're going to hire that investigator to see if you ever had a prior injury, or maybe they already have. They want to know your name and your age and your date of birth and your social security number and where you live and where you lived before that, and whether you were ever in the military and whether you were discharged honorably or dishonorably, and all those type of things that take a long, long time. And I've been in deposition for full days or multiple days before. And so there's the discovery deposition, where they get to ask you anything that's legally relevant. That means that it's likely to lead to discoverable information, including hearsay. What did, you know, Jane say after that? Well, that won't come in at trial because hearsay is an out-of-court statement intended to prove the matter asserted, but basically hearsay is what someone else said, and the best evidence of that is to bring that other person into court. But in a deposition, they can ask you those things in a discovery deposition. You know, what did that person say? What did that person say? And even though you may object, that stuff is a fair question in a deposition. Now, an evidentiary deposition is a little bit different. An evidentiary deposition is the deposition that we are using for trial. So the defense may take a deposition of a witness to discover facts of, like my client, and they may take a discovery deposition of our expert for trial, for discovery purposes, but for trial, I may take that witness's deposition. So I may go to our orthopedic surgeon in federal court, or even in Missouri State Court in workers' compensation. I can go and take that person's deposition for evidence purposes, and I just go to the judge or the jury or both, and I say, this is our expert testimony, and we can read it in. I sometimes have another lawyer from my office take the stand and play the part of the doctor, and we just read the deposition. So that's an evidentiary deposition. It's different than a discovery deposition. In most cases, the defense will do a discovery deposition. And I'm a cynic. I think that some of these firms are taking that because they're billing by the hour. You know, we're on a percentage. We never charge a fee unless we win. It doesn't matter if it takes an hour or 10 hours or 10 days. But the defense is paid, you know, 400 hours an hour. They're going to take that deposition for 10 hours and then make an extra $4,000. Of course, they're going to deny that, but I think that happens all too frequently. So if you have questions about the deposition, you can watch my other video about depositions, but if you want to know why they take your deposition, that is why. My name is Mark Cantor. It's my firm, Cantor Injury Law. It's all I've done for 25 years is personal injury, helping injury victims and their families. So if you need any help with the case or have any questions, please call us 314-628-9999.